Ndị be anyị ekeneni m unu ọzọ n'ụbọchị nke taata. Asịrị m unu ka ọ dịrị anyị na mma. Asị m na ihe adị ka echi na echi ada agwụ agwụ. Ndị gị si na-esonyela ihe a bụ Igbo Media, bụ ebe anyị si wee na-ewetara unu ya bụ ngalaba ozi a dị nnukwu mkpa. Anyị si ka anyị gosi unu gbasata maka ihe na-eme na Igbo community and obodo anụ anyị nọ n'ime ya. Dịka o si dị, ọ bụ na nke a bụ mbọsị izizi ị na-ezite chanel anyị bụ Igbo Media, gbaa mbọ rinne ka ị sọskraịbụ and share ya ka o rute ndị ọzọ aka. Maka na infọmeshọn anyị na-enye unu bụ ihe unu ga-ama gbasata maka ihe na-eme n'obodo a, anụkwunu mara ka unu si akwado na ya bụ ife bụ ya ka anyị si ka anyị drọpụ ọrụ bifo anyị gosi unu ihe anyị ji maka ya wee bịa. Ị ga-esi ya bụ ife anyị ji maka ya wee bịa, ị drọpụrụ anyị alụ gị ife iche gbasata maka ya bụ ife ndị niile ekwu n'iru akwụkwọ. Alright, over to you, sir.
We felt it has become necessary to brief the members of the media on certain salient, certain very important developments in the case of Mazi Nnamdi Kanu. Me being the first speaker, I'll briefly touch on the history of this case, and I'll turn over the mic to my colleague here to take the other segment of this briefing. You will all recall that this case started in 2015, sometime in October, when Mazi Nnamdi Kanu was arrested in Lagos on his arrival from the United Kingdom. Then he was charged with 4 or 5 offenses, mostly bordering on treasonable felony. One was treasonable felony by itself, the other one was conspiracy to commit treasonable felony. There was also a charge that bordered on defamation of the then president, and one that bordered on false declaration of an imported radio equipment. The case initially made its way to the magistrate court in Abuja, where in December 2016, the DSS, which had brought the case forward, filed a nolle prosequi. They filed an application before the magistrate court to discontinue his prosecution in the magistrate court on the premise that they were moving over to the High Court. And that was granted. Thereupon, the case moved over to the High Court, and it was in the High Court. And during that period, between 2016 and 2017, Mazi Nnamdi Kanu was granted bail twice. The order for bail was not complied with by the federal government. And one of the judges, Justice Adeniyi, who granted him bail unconditionally, became a casualty of the federal government. It's in the public domain. It was widely published then, in accordance or quoting the judge himself, that part of the reason he was arrested subsequently and tried in court was because he had granted unconditional bail to Mazi Nnamdi Kanu. Anyway, in the very end, sometime in April of 2017, he was finally granted the latest bail then by Justice Binta Nyako. That was the bail that he perfected and which the federal government obeyed. So he returned to his ancestral home in Omaha, awaiting his next court date, which was in October of 2017. But lo and behold, between the 10th of October and 14th of October, the Nigerian army started or commenced lethal military invasion attacks at his ancestral home in Omaha. Several people were killed. Mazi Nnamdi Kanu's parents were both alive, but they suffered injuries to which they later succumbed to and died 1 week apart. Nnamdi Kanu himself, in order to save his life, had to flee from the location, and fortunately for him, he found his way overseas, and he remained in exile until June of 2021, when he was encountered in Kenya by Nigerian security agencies who have been on a manhunt for him. They laid ambush for him at the Jomo Kenyatta International Airport, and they abducted him at the parking lot of the Jomo Kenyatta International Airport, where he had gone on a personal errand. From then, he was disappeared for 8 days at a secret location in Kenya, not a law enforcement location, facility. He was disappeared, and during those 8 days, he endured horrendous physical and mental torture. Eventually, on the 8th day, they brought him out from that location and secretly took him to the tarmac, straight to the tarmac, evading immigration, Kenyan immigration, put him on a private jet and renditioned him to Nigeria. He wasn't extradited. Most of these things are in the public domain. I'm doing this just to recap, so that the public and the media in particular will be aware of how this case is now turning from prosecution to persecution. After he was brought into the country, the federal government, instead of pivoting on the charges for which Mazi Nnamdi Kanu was so unlawfully and forcibly brought into the country, totally abandoned those charges, all of them. But for one, the one that bordered on false declaration of an imported radio equipment. That's a very unserious charge. The more serious ones, bordering on treasonable offenses, were completely abandoned in place of new ones, 15 of them, bordering on terrorism. What this means is that for a whole 7 years, between 2015 and 2017, 2022, when these charges were finally amended to 15 and the old ones abandoned, the charges I will characterize as pre-rendition charges were completely abandoned. Mazi Nnamdi Kanu suffered at the hands of the criminal justice system in Nigeria for 7 whole years, between 2015 and 2022, for charges that were later abandoned. So for the 18 months he was detained, subsequent to his arrest in 2015, he was detained for nothing. He didn't deserve 1 day of that detention. He also didn't deserve any tribulation and travails that he had to go through for these 7 years, including the Python dance that nearly claimed his life, but claimed the life of his parents and other innocent people, including his exile abroad and including his rendition. So you may ask, why was he renditioned? For charges that were later to be abandoned. That's a question for that the answer will come 1 day sooner than later. Now, you all are aware of what happened in the High Court. The High Court, in response to objections filed against his trial, struck out 8 of the charges, leaving 7 in place, which went to the Court of Appeal. The Court of Appeal proceeded to strike all of the charges due to the extraordinary rendition which the Court of Appeal held had divested Nigerian courts of jurisdiction to try him. So he was discharged and was supposed to go home pursuant to that order of discharge. But the federal government did not obey that order. For a whole 2 weeks, he was looking for a way to dodge it, and finally he found a way by filing an application for stay of execution of the order. And the application was granted in a swift way that really would shock everybody in this country that knows that matters like that are often very much delayed in court. But I'll leave that aside. Eventually, the case proceeded to the Supreme Court, where the Supreme Court held that he must stand trial. In other words, the Supreme Court reversed the judgment of the Court of Appeal, but the Supreme Court also made other rulings. that the revocation of his bail was wrong, the warrant of arrest upon which his rendition from Kenya was granted was wrong, that manifest misrepresentations were made to the High Court by the federal government that he had John bail, and the High Court was misled and otherwise did not pay too much attention to the explanations as to why Mazi Nnamdi Kanu was not available to take his trial. And thereby, the trial court proceeded to issue that questionable warrant of arrest that led to his rendition. Now, the case has been remitted back to the trial court, the High Court, and we're here, the legal team, battling to defend him the best way we could. We have done a bail application, a fresh bail application, which was denied. We raised objections to his trial due to the fact that we are not able as a team and individually as lawyers, when we visit him at the detention facility at the State Security Services in Abuja, we are not able to consult with him properly. He deserves his right to counsel, unfettered right to counsel, unburdened by interference of government officials. He also deserves to have the adequate facilities to defend himself. These two things are denied him, and they are constitutional rights found under Section 36, sub 6, B and C of the Constitution of the Federal Republic of Nigeria. Every one of us enjoys such a right. It's called right to fair hearing. I don't see why Mazi Nnamdi Kanu should be an exception. But lo and behold, the High Court, in its wisdom, denied our objection and ordered for an accelerated hearing. So that's where we are now. We have the matter scheduled for hearing on the 17th of April. And before then, we decided we have to bring some other applications. So right now we have one application pending, which is to restore his bail. The application is different in so many different degrees from an application for bail. While one was an application for a new bail, the other is an application, or the current one is an application to restore his bail under the conditions that it was previously granted. That application is pending. But then, on a final note, when this matter started in 2015 and escalated to September 2017 with Python dance and all that, Mazi Nnamdi Kanu, through myself, brought an application before the African Commission on Human and People's Rights, complaining about the Python dance and proscription of IPOB, and he won. The African Commission, which is a branch of the African Union, wrote a letter to the then president calling for implementation of certain things they asked him to do. One of them being that he should henceforth or thenceforth cease and desist from further prosecutions or law enforcement actions against IPOB members, and in particular Mazi Nnamdi Kanu. That decision was ignored. The United Nations intervened in 2020 and 2021 with similar decisions. Those two were also ignored. After his rendition, the United Nations intervened again in July 2021 and issued a celebrated opinion that he should be released unconditionally. That too was ignored. Now, a high court, a federal high court sitting in Omaha in October 2022 issued a decision condemning his detention, declaring it illegal and unconstitutional, his current detention in Abuja. That too was ignored. Back in January 2022, a high court of the state of Abia had awarded him 1 billion naira as compensation for the damages he suffered or that issued from that infamous Python dance. Payment of that compensation is outstanding, so also is the apology to him that the court had ordered. And then finally, last year in October, a high court in Enugu State declared that the executive or administrative actions taken by the Southeast governors and the federal government back in 2017 to proscribe IPOB and declare it a terrorist organization, those actions were unconstitutional under Section 42 of the Constitution. This is important because all Nigerians are supposed to be treated equally. What had happened to IPOB in 2017 in terms of the proscription was a stark evidence of discrimination, which is unconstitutional under Section 42 of the Constitution. We have been saying that until last year in October, when a high court agreed that that is so. We had figured that in an enlightened society such as ours, which is subject to rule of law, the federal government would have taken steps pursuant to that judgment of October last year to file some sort of an application to withdraw the proscription of IPOB as it is and to cancel the terrorist toga that is placed on IPOB. Why? Because that very proscription in 2017, being ex parte, did not give opportunity to IPOB or any of its members to make representations as to why it should not be proscribed or as to why it should not be declared a terrorist organization. That offends Section 36 of the Constitution, which required that any law that derogates from the right of any Nigerian, his right to fair hearing, should have given him an opportunity to make representations. So these are the several violations, and unfortunately, these violations have led to incalculable damage to citizens of this country, to innocent people, mostly in the Southeast and South-South. Hundreds have been killed in pursuit or in law enforcement actions related to fighting IPOB. It's wrong to do all that on a mere ex parte order. Thousands are languishing in detention, and of course, you know, Nnamdi Kanu himself is also languishing in detention following his rendition. So too many bad things have happened, and we're hoping that we'll come full circle to a point where people will sit back, government officials, the federal government, led by President Ahmed Tinubu, to look again at this case and to see whether this case has any merit at all, or whether the case was, as it were, politically motivated to the point that the present administration should not have any business inheriting it. When someone says, I do not want to belong to a country anymore, you don't lock him, you don't pursue him with bullets and manacles and all kinds of things to put him in jail or to prosecute him. You try to talk to him. That, I think, is the more sensible thing to do. No, what we are saying is that he was speaking from experience. He even cited himself as an example. There was a day he went to see him. They wouldn't allow him to see him. That was about 3 or 4 weeks ago. So that exemplifies what we passed through. And when we go in there, we can't see him as a group of lawyers. They separate us. I see him for 30 minutes and they rush me. I go out, he sees him, they rush him out, he sees. So there is no cohesion that is required to defend such very grievous offenses or allegations. So those are the things we're battling with here. And we have concern about the privacy of our conversations. There was a day I was consulting with him with another colleague, and they took a secret photograph of myself. They accidentally filed that photograph as part of their proof of evidence in court. So we now got it as an evidence, and we said, wow. So they were taking secret photographs of us. And if you go into the room, you will not see any camera. So evidently you have hidden eyes, hidden cameras and everything. So what and what not? So what else do they have? If eavesdropping equipment, secret listening devices or what? So we whisper in fear. And sometimes you just have to pull him out to say something, or even pull yourself out to say something, because you're ever afraid someone is somewhere secretly recording you. How can we conduct an effective defense under these conditions? It's not possible. Okay, whether we are confident that you get a fair trial, the confidence is zero. Under present circumstances, our confidence is zero, nada. My colleague said it here. There's no way Mazi Nnamdi Kanu can get fair trial under the current conditions of his detention, which encourage the profound interference with his access to counsel and the adequate facility to conduct his defense that we initiated earlier on. There's not going to be any fair trial in that kind of scenario. Impossible. The drafters of the laws of Federation of Nigeria are wise. There is a section in the Federal High Court Act. You can check it out. Section 17 of the Federal High Court Act empowers Federal High Court judges to recommend reconciliation, otherwise known as political solution, in this very circumstance between combatants, between the prosecution and the defense. And it did not limit it to civil cases only. It includes criminal cases. And we are human beings. We are imbued with the capacity to talk, to negotiate, to compromise certain things, to do give and take. So anybody that puts that issue on the table, it will be considered. The issue of political solution. I alluded to it earlier on. The agitation itself is political. So it fits into the mold of the agitation. Political solution makes better sense than law enforcement.
Have you initiated, or are you going to?
Would I suggest it?
Yes.
Well, I'm saying I'm a lawyer. I'm transactional. It's for the government to put it on the table that, listen, you are agitating for something, and that's why we're holding you. Can we talk? Then we consider it. We're not going to reject it flat out. It will not make sense. Political solution is always possible. I don't think it makes sense to reject it, regardless of where it's coming from. Well, it will be our duty first is to defend them, not to play politics, and not to recommend political solutions, like what my colleague called line of defenses. That's what we are struggling with. Right now, what is on the table is we are fighting to make sure he gets fair trial. So we're not fighting to get a...
Ndị be anyị daalụ nne nụ ihe a bụkwa Igbo Media anyị si wee na-ewetakwara unu nnukwu ozi a dị oke mkpa dịka anyị si kwuo unu nkwa na dịka anyị si na-agba mbọ ewere ike ị na-enye unu update bụ ihe gbasara maka ife na-eme na ana Igbo be anyị na ndị nwere onwe nke a na-azọ. Ọ ya bụ nkwa ka anyị kwere unu na anyị ga na-emezu ya. Ọzọ dịka ibe ya bụ iwe ọchịa ihe a kịta ị nụrụ n'elu akwụkwọ Biafran Prime Minister kwuru, gwa onwe gị eziokwu n'ụdị nke gị na nchịkọta mmụọ gị ka ghara iwelitela anyị n'ihe ya, maka oke ihe ga na-esi na-emezi. O nwere ebe ekweta na ndị Igbo ya anọ, o nwere ebe anyị sịrị anyị nọrọ. Igbo abụlọ Senate President, Igbo abụlọ Vice President, nothing. And na ụmụ ihe ndị niile amegasịkwa anụ ụmụnne anyị esokwu na-agba ụwofa mgba maka oke ife ya je megidezie ajụrụzi asị ma ọ gịnị na-emezi ọ dị ka arụ achọziri ime anyị negodin ka obodo si dị ka e mere ji jide nwanne anyị nwoke bụ Mazi Nnamdi Kanu na mkpọrọ akwa maka ndị Igbo. Gịnị ka ihe ọjọọ mere? Maka ọ sị na n'Igbo ga-adị, maka ọ sị na anyị ga-adị ka echi na echi ada agwụ agwụ. ọ nwere ihe ọzọ eji jide ya? Jụọ onwe gị ajụjụ a, gịnị ka eji jide Maazị Nnamdi Kanu? Ọkwa maka ọ sị na Igbo ya adị? Biko ọtụtụ dị ka iwe chetara ife a bụ Igbo midia anyị na-asụ n'onu be anyị, ọnụnụ be anyị ka anyị na-asụ. So biko ọ bụ na ede anụ Igbo, iwe ewena gị, ọnụnụ be anyị ka anyị ji akọwa ihe na-eme ebe a. Ka ego ọkwa na ya anyị na-ekwu bifọ, unu ekwe n'iwe ka ife onye ndu melụ, ọ sị na ya na-eme mgbomgbe ndị Igbo na-abịa ya n'alụ, ọ na-ewute ya. Simon Ekpapini ya anyị agbaba ya mgba ka e mere obedient movement. Akwụwụrụ okwu Maazị Nnamdi Kanu kwuru before ejide ya, they will never give you that president, that seat. Akwụdoro na ya na Peter Obi winere mana nyere ya. Gịnị ka nsị ya bụ? Mba, Igbo mana na ife maka oke esi na-ekwuzi okwu ọka ife ga na-esi na-emezi. Ọ bụ na ịkpọrọ onwe gị mitin, chụkọ onwe gị ọnụ, jụọ onwe gị ajụjụ a, ka ebe ịkwụ n'obodo a bụ Naijiria. Ajụ nchọkwa onye ọbụla bụ onye Igbo na-ege m ntị n'elu akwụkwọ a, jụọ onwe ya, na na-ejicha onwe gị ya bụ ife isaa ya. Ọgwụna ka m n'ọnụ, ihe a bụ Igbo midia. Daalụ n'ụmụnne.